ladies and my lords, good afternoon. I've done the common law principle of legality, but you'll be well aware that there is an ECHR backdrop to the legislative change and changes over the years in any event. And you can effectively, therefore, get to pretty much the same point as the principle of legality without even having to use Section 3 of the HRA or anything of that kind, because obviously Section 3 only applies if there's established incompatibility. But you can get there more traditionally by recognising that this legislation has been, over the years, specifically shaped by the desire to comply with the international obligations that the ECHR used to impose on the UK before the HRA. And
is this still part of point 5?
This is still part of point 5, it is. I'm simply on approach under point 5. Sorry, this is going to take a little development. I'll pull the points together in a second. But so you've got principle of legality, common law and ECHR, and then you've got the more general and traditional principle, which is that Parliament is presumed to legislate compatibly with international law, certainly if there's ambiguity. Well-known passage from Lord Millett's judgment in Gaydon and Mendoza at paragraph 60. I'm not going to turn it up. Authorities 3, tab 27, 1256 in the MS numbering. And we've explained, I can perhaps take this shortly, if you go to our case at paragraphs 15 to 18, we've sought there, I hope fairly, to summarise a bit of that history. And 15 to 18 deal with the consequences of the government having lost X and the United Kingdom. If you want to go back to X and the United Kingdom, it's in Authorities Bundle 5, tab 43, and the MS number is 1783, if you want to write that next door to paragraph 15. But that led to changes in the 1982, as it then was, legislation. And the purpose of the changes that were then made were to give powers to the tribunal, so they were no longer advisory but could in effect order discharge, and to make changes in relation to the periods governing the rights to review, which I'll come back to. But the essence of those changes was designed to make the scheme, the whole legislative scheme, as it was put by the minister presenting the bill, Strasbourg-proof. That was
some hope.
Some hope, quite. But that was the purpose of it. But that's 15 to 18. Those were the changes from X and the United Kingdom. Perhaps more to the point, there were then further legislative changes, which we describe, and you'll see the echo immediately from the Court of Appeals analysis in RB, to which I'll come back in a second, but the changes consequent upon HL and the United Kingdom. More to the point, because this change was to the degree of prescription in the legislation. The vice in question, identified by the Strasbourg Court in HL, was that the scheme did not deal with the safeguards criteria and all of that, to do with detention on the basis of common law necessity. And it didn't set out the procedures and the criteria in any detail.
It says it in the sense of the incapacitated patient who was dealt with on the basis of necessity.
Yes, I think that was it. And the problem was...
That was HL, wasn't it?
Yeah, that was HL.
The problem was that there were no safeguards for the compliant incapacitated patient. The common law justification for whose, if it was de facto deprivation of liberty, which they held it was the doctrine of necessity. That's what HL was about.
I'm very grateful. And what it led to...
That led to the dolls.
That led to...
The dolls.
The dolls, yes. But the vice was a lack of prescription. That's why the Court of Appeal in RB considered it to be of Interest. So if you just jump, if you would, if you still have RB out there, marvellous. If not, it's paragraphs 11 to 14 of the B case. So paragraph 11 is on MS 325. Yeah, volume 1, tab 5, MS 325, and there they deal with and explain what HL was all about. And it leads, for present purposes, relevantly, to the summary of the principle, which is, we respectfully submit, entirely accurately described in paragraph 14, Roman 4, on page 326 in the judgment of Lady Justice Arden. So we're Authorities 1, tab 5, MS 326, para 14, Roman 4. And essentially, Romans 1, 2, and 3 will be very familiar. They're from Winterwerp, but 4 is HL. And that principle is then given flesh in the present context in that judgment at paragraphs 48. Where Lady Justice Arden says in the second sentence of 48, the Strasbourg Court has made it clear that such an important matter must be prescribed by law, and that includes a requirement that the grounds on which a person may be deprived of his liberty when an order for conditional discharge is to be made, and the grounds on which he is entitled to be released from the conditions imposing a deprivation of liberty, must be found in legislation. I call this the prescribed by law issue, and she then develops that theme by reference back again to HL and the United Kingdom, and expands on what it means in paragraph 54, which you've already seen. And the same point, the same description, and the same punchline, as it were, from HL, and I won't turn it up now, but if I can just give you the reference, the same treatment of it is in effect in my lady's judgment, Lady Hale's judgment in Cheshire West, at paragraphs 6, 7, and 8. Authorities 1, tab 6, page 355 and 356. So there are two key points emerging. I'm still on to the fifth point, I'm afraid, but two key points emerging, therefore, from this approach. The first of them is a general point of interpretation. The legislation is evidently designed and has been set up so that it can be, if possible, faint hope perhaps, Strasbourg proof, and to include, therefore, the requisite degree of prescription, a specific past failure. That is, therefore, that desire to implement our international obligations in that way, because obviously it was 1982, 1983 changes prior to the HRA coming into effect, that in itself would be a legitimate reason for interpreting conditions and meaning and so on in accordance with that aim.
HL, one of the problems with HL was it that he hadn't got any kind of right of review by anybody, any kind of court.
I think there was almost nothing.
There was just nothing, I think.
There was nothing by way of criteria or anything. It was just a common law principle.
He's a compliant but incapacitated patient. Supposing there had been a right of review to a tribunal or a court, some kind of what Strasbourg would call a court, simply on the basis that the necessity of giving him treatment had to be justified. No more than that.
Well,
would that be enough?
Then the answer is you'd have had an argument about whether or not merely prescribing matters in that way was sufficient.
Right, but
but
what's wrong with prescribing it in that way?
Well, we mustn't forget that, in fact, HL had gone to court.
Through JR?
Through a judicial review, yes.
Habeas corpus, I think.
Yes,
habeas corpus.
Yes.
He had gone to court.
Yeah.
And
they were able to review the legality of the detention and therefore the necessity, and that was held not to be enough anyway.
It wasn't enough for Article 5.4 purposes, because JR is generally not held to be, in
this sort of context.
In the X case, it was held not to be enough.
Yes.
Because it's got to be...
Not a merits review, is it?
Exactly.
That's the
It's got to be
point.
a merits review.
But supposing that he'd had a tribunal which was entitled to say, you may say it was necessary to take this chap into this hospital in order to treat him. We are going to require you to demonstrate that. We want medical reports. We're going to go into the merits of it. Would that have been enough? And if not, why not?
As I say, then at that stage you get into a debate about the degree of prescription that is necessary.
Exactly.
And if you say it's pure necessity, and that's the only thing you're worrying about, there would still have been an argument about whether or not you had, whether it was sufficiently clear what criteria you were applying, and whether or not the conditions on which you could apply to be released from that condition were set out. I mean, there are a variety of things, and unsurprisingly, perhaps in this particular context, Strasbourg has been pretty insistent upon a pretty high degree of prescription. Just generally in the mental health sphere, where one sees it from HL.
I'm struggling with that a bit, because the passage from HL, which is quoted by Lady Justice Arden, is concentrating more on procedural safeguards than it is on substantive criteria. And the Winterwerp substantive criteria are pretty broad. It's the lack of any procedural safeguards that was really seemed to be the cause of concern in HL. You know, there were no prescriptions to who could make the application, who made the decision, review, and all the things, you know, the things like needing medical recommendations and so on and so forth. Those seem to be the things that were concerning them more, rather than that the grounds were prescribed in detail, because in Winterwerp that doesn't require very much.
It doesn't require very much, but you've still got to know what the base criteria are, as it were. You might still be in trouble as a domestic law if you were to just say, well, a person of unsound mind, say. I mean, but I'm sure my lady is right about HL. It was focused principally on the procedural side of it. But I do respectfully submit that if you're dealing with something which is entirely general, you've still got a problem if you don't set out the criteria at all. So there is that substantive element to it. You can't just leave it blank and in the air and say, well, Winterwerp will fill the void. And that obviously wouldn't have worked in the context of the 1982 changes when made, because Article 5 wasn't yet part of domestic law at that stage. So the first point is a point about interpretation. The second is a point about the application in the present context of that principle. And I do submit that there's a need identified to set out on the face of the legislation the criteria for detention so that the patient knows where they are and can bring effective proceedings. And that is the point that was made by the Court of Appeal, Lady Justice Arden, at paragraph 48 of that judgment. Prescribed by law includes a requirement the grounds on which a person may be deprived of his liberty, and an order for conditional discharge is to be made, and the grounds on which he's entitled to be released from those conditions must be found in the legislation. And it's likely to be unsatisfactory if the scheme sets up, in effect, a contrast between, and I'm using words from 120 of HL, cited in para 12, if you just flick back to para 12 of Lady Justice Arden's judgment and look at quoted paragraph 120 from HL at the top of MS 326. It's likely to be unsatisfactory if the scheme sets up a contrast between, quote, an extensive network of safeguards on the face of the legislation, on the one hand, and a dearth of regulation on the other. And again, I think that was a contrast that my lady picked up on in Cheshire West, that was a particularly striking feature of the HL judgment. There you had a compare and contrast exercise. On the one side, a wizard set of safeguards, criteria, and all the rest of it, and on the other, a blank or a general power at best. So the submissions applying that approach in the context of Section 73 and its provisions about conditions are as follows. The power to impose conditions is simply a general power. It does not provide clarity or specificity required by the principle of legality, common law, or ECHR interpretive. The provision does not, as Lady Justice Arden explains in clear terms in paragraph 54 of her judgment, explain the legal basis on which that is, the circumstances in which a person could be subjected to an order for conditional discharge to an institution other than a hospital on terms that deprived him or her of liberty. And as she puts it, section 73(2) simply doesn't address the reasons, and this is the final sentence of 54, the reasons why in any particular case there is a need for him also to be deprived of his liberty. It simply provides that he can be discharged conditionally if there is a need for him to remain liable to recall to hospital for treatment. In other words, that absolute discharge isn't appropriate. And nor does it explain the circumstances in which a person could be released from this new form of detention. In short, therefore, to jump between courts of appeal, as Court of Appeal put it at paragraph 20, I quote, "The power would be unconstrained without criteria, time limits, or analogous protections." My respectful submission is that the things that section 73(2) in this context does not do, or do not do, damn it under the principle of legality or the principle of interpretation that I've indicated. And as we saw from the Algerian case, that principle applies not merely to the executive, but to powers conferred on judicial bodies. So not merely do we not have express powers to detain under 73(2), we don't have anything other than the general powers, and we have already seen that there are a series of indications within the text of the legislation anyway that tend to suggest that detention is not something which was envisaged by Parliament under 73(2). But that does lead, mercifully off the fifth and onto the sixth point, that does lead to the main one, which I know you're already well aware of, which is that it would create a scheme of detention under which the rights of the individual are markedly inferior to those of a person detained in hospital, despite similarly being subject to a deprivation of liberty. And there are three aspects to that, perhaps. The first is that the problem exists potentially, at least at a basic level, if the discretion of the tribunal to impose conditions amounting to deprivation somewhere other than a hospital is at large, that opens up at least the possibility of it being exercised in a broader range of circumstances than the very tightly controlled situations set out expressly in the Act. And those are the points that Lady Justice Arden, if I've read her judgment correctly, is making at paragraphs 57, first of all, see particularly the final sentence, and then again on the same theme.
Sorry, could I have a...
57, my lady, I'm so sorry, 341 in the MS. I was particularly drawing attention for this purpose to the last sentence of 57. And then 62 on the same theme, on page 342. Now, I fully accept...
Is there any power to impose treatment on a conditionally discharged patient?
I don't know the answer to that.
It's a bit relevant, isn't it?
Whether you could impose treatment. Thank you.
I think the answer is no. I think it's a standard condition that the patient, if we may still call him that, complies with the instructions of supervising clinician, because there will be a clinical supervisor, but it isn't a situation in which he can be forced to do so. That will merely be a situation in which recall would be considered. Yeah. So, that being, That's a point that's probably in your favour.
Well, that's a marvellous thing then.
Some-
Then I adopt it entirely.
It has to be relevant to the argument as to
Yes.
whether there is power to impose
Well,
treatment.
if the purpose of the Mental Health Act is a combination, it is actually a combination of treatment and containment, isn't it? And the containment is both in the interests of the individual and also of the public, particularly, obviously, if it's a restriction order. But in fact, in any case. So if the purpose is that, it's a mixture of safety and treatment, why does it not follow that any conditions that are imposed must be aimed at serving those?
Well, my lord, I was going to come on to make that point. And it's an entirely fair point. One answer to that final sentence of paragraph 57 is to say Padfield, which is effectively the point you're putting to me. But there are potentially within that shades of grey. And you'd have to have an argument about whether or not in a particular circumstances you could or you couldn't do it. And that is not the same as the degree of prescription which would exist when you're detained in hospital. That's the short point.
That's the degree of prescription point.
That's the degree of, exactly. So, I mean, I fully accept that there is a public law principle that says Padfield and purpose constrains executive or judicial action.
Well, the reason I was asking my question was that I wasn't entirely sure that the purpose of conditional discharge was
as simple as that.
as simple as the final sentence of paragraph 57.
My lady, yes. And I don't want to overstate this first point because Padfield plainly has a role to play, but it creates, as it were, an additional level of complication and, if you will, highlights the discrepancy that exists, the HL problem, which is here you've got a detailed scheme of regulation, on the other side you've got nothing and you've got to start inventing controls through the application of general public law principles, which may be subject to all sorts of difficult arguments and shades of grey and so on. And the key point flowing therefore from that remains that is it really to be supposed that Parliament intended to authorise a new species of detention without putting into place those equivalent express?
I'm wondering if you're right.
Safeguards.
What conditions, forget about deprivation of liberty, what conditions of any kind can be imposed? And how you test whether they're legitimate or not.
Well, you don't have quite the same problem, do you?
You don't have an Article 5 problem apart from the deprivation of liberty. Absolutely, but what is the test for the legitimacy of conditions?
Well, it would
if it isn't Padfield.
It probably is. It is probably Padfield. Yeah, you've got to exercise your power consistently with the purposes of the Act as discerned. But the reason we're having the argument, I mean, you see the way the arguments get presented. My learned friend says, well, there we are, we've got no implied limitation. It's general, so that's jolly good. And we say, it's general, but see the principle of legality, that's jolly bad. I mean, that's in the end, that's the issue of approach that divides the parties. But we do respect, and that's why we're having all the debate about what Article 5 brings to the party. But we do suggest that's a potential problem. But I entirely agree that if you strip out the principle of legality, you've got the controls that public law would impose on a decision maker of that kind. They'd have to exercise their powers in accordance with the purpose and scheme of the legislation. They'd be the usual controls.
But by definition, in respect of a person who does not fulfil the criteria for detention in hospital.
Because otherwise...
By definition, because otherwise he would not have been discharged at all.
Yeah, I think you're right. Yeah, so it all comes back to that sub-para B, as it were. Yes. The second of the aspects is the clear and hard problem relating to rights of review. And that is referred to by Lady Justice Arden at paragraph 28. If I can just invite you to, if I can take the submission, as it were, via the judgment. Para 28 identifies the problem. See the first half of it, or the first few lines of it. And then paragraphs 63 and 64 in her judgment set out the interpretive conclusion. And the interpretive conclusion, in a nutshell, is the one that you see in the final sentence of paragraph 63. There is no apparent reason for that disparity of rights.
Isn't there a difference between the patient who is still in the hospital and the patient who is not, but is liable to recall? Because that's the distinction which the statute makes as to the periods between reviews, isn't it?
It is.
Is there not a distinction between them?
I submit, well, there obviously is a difference, but I submit it's not a relevant distinction, because if to be a relevant distinction, it would have to sound into the prolonged period of detention. And if you're positing here a situation in which both are deprived of liberty, that makes no sense at all. It isn't a relevant distinction because they're both deprived of liberty. And that was the point that Lady Justice Arden makes, and if you want the same point being made describing the difference as stark and appropriate to describe it as an inferior right of review, creating real Article 14 difficulties, Court of Appeal, paragraph 20. And my learned friend, I think, and maybe it echoes the question my Lord Hughes just put to me, my learned friend appeared to have two suggested answers to this difficulty for the case. And the first is, well, it's a lesser deprivation. That's the first answer that he gives. The problem, of course, with that is that as the discussion this morning progressed, my learned friend accepted and asserted that on his case, the tribunal could impose greater restrictions, at which point you've got greater restrictions of liberty, both amounting to deprivations of liberty, but greater restrictions of liberty within that bubble of deprivation, 1 year versus 2 years. That's why I say not a relevant distinction, because it's simply inexplicable. It's incoherent to have different rights of review in that situation. But even if that were not right, and even if the power for which he contends could only be exercised where some lesser restrictions of liberty are put on, that still doesn't solve his problem, because the lesser restrictions could and would, no doubt, in individual cases, exist across a range. Some of them would be further away from deprivation of liberty, and some of them would be, thinking back to control orders, nose up against the glass. 15 hours versus 14 hours under house arrest. I mean, they're fine distinctions, but you could have a restriction of liberty that was only just not a deprivation, and you'd still have 1 year versus 2 years, because the 1 year versus 2 years thing is dependent upon a categorical difference. You're either detained in hospital, in which case you get the better right of review, the shorter period of review, or you're not. That was the first answer my learned friend gave. Second answer he gave was consent. They consent to it as part of the package. Well, I'll come back to how that idea might work when I deal with consent more generally, but it appears, therefore, in essence, to be a plea of waiver of a possible discrimination difficulty. There's nothing to suggest that anyone in this circumstance has explained to them that difference. But in any event, even if that were so, it's very difficult to see how the possibility of consent could be a pointer to interpretation in this sort of situation. There is incoherence on his case on the face of the legislation. Why would Parliament create that choice? Just doesn't make any sense. The third and final aspect of this sixth point is a much smaller point, and it to some extent flows from the second. Section 132 of the 1983 Act is at page 235 behind tab 1 of bundle 1 of the authorities, MS 235. And the short point is that the scheme of the legislation envisages hospital managers providing information about their rights to patients who are detained in hospital. And the short point is that that wouldn't apply, and doesn't apply, to create an equivalent right, I don't think, to people in the situation that my learned friend is dealing with. And so you've got a difference of right provision. Whether that would be sufficient to mount a serious Article 14 claim one could argue about, but it does demonstrate that Parliament is providing for specific information to those whose position is most seriously affected by the deprivation of liberty that is detention in hospital. So that's the sixth point. The seventh point is a two categories point. I can take it tolerably shortly. You will have noted that there are two different scenarios which may present themselves at the Section 73 conditional discharge stage. And they were identified and indeed formed the basis for the House of Lords decision in H, the Lord Bingham decision behind tab 4 that you were taking to this morning. Especially for this purpose, see paragraph 28 at MS 318 and 5, back end of paragraph 5, which puts a bit of flesh on that. But the two categories are the patient who, if he complies with conditions, can be conditionally discharged, but otherwise would have to remain detained in a hospital. So for that category, the conditions form a necessary part of the ability to allow conditional discharge at all. And secondly, a patient who must be discharged, either absolutely or subject only to the continued power of recall, even if conditions to aid their reintegration into the community cannot be arranged. In other words, patients who don't need to be detained and treated in hospital, full stop, and so have got to be discharged, either absolutely or conditionally. So you've got those two categories within Section 73, and the scope of the power in 73 is the same for people in both categories. The statute doesn't differentiate between the two.
You've got second category, Mr. Jones.
The 73.
You only get to conditional discharge if you, wearing your tribunal hat, are sure that they ought to remain liable to recall.
Yes, but the second category is the person who's got to be has got to be discharged because either absolutely or subject only to continued power of recall.
Nobody has to be discharged conditionally, do they?
They have to be discharged conditionally if the tribunal is not satisfied that they shouldn't be subject to the power of recall. You can discharge somebody conditionally with the only condition being that you are subject to the power of recall.
Yes.
Because Section 72(5)(b) says the patient shall comply with such conditions, if any, as may be imposed.
Yes. So you've got those two categories within.
Hence the two categories.
And the short point is that our case obviously concerns the first. You can't release him unless the condition can be put in place. That's a precondition, as it were. But consider a person in the second category. How then would that power to detain work in the category 2 cases? It just doesn't make sense for it to work in those categories of cases. How could you have a deprivation of liberty or a condition that amounted to a deprivation of liberty in those cases?
Wouldn't. If they're in that category, you can't.
Well, the conditions would still apply, and it indicates, well, we respectfully submit it indicates, that the existence of those two categories, it would be very surprising if there were fundamentally different operation of conditions in relation to both.
Pretty difficult to get one's head round.
Well, then I will...
I'm afraid. You're positing a class of patient who has to be discharged because the criteria for detention don't exist, but the tribunal is not satisfied that it shouldn't remain subject to a power of recall, but the tribunal also doesn't think any further conditions are necessary. If that's the case, well, then the problem doesn't arise.
Well, no, but I see that. There are, however, the two categories within it And the condition power, the condition-making power applies to both. It may be that in all cases in the second category you'd never get there, but it is at least strange if one's thinking, has Parliament intended to set up, in relation to this power, two categories within the same species, as it were, one of which you can deprive of liberty and the other you can't? And again, the answer may be a combination of the points my lady's put to me or Padfield, but it becomes complicated, I submit. The eighth point I'm not going to expand on at all, other than to say it's the language of discharge and the meaning of the term discharge, and I fully accept that to some extent that is a question-begging point. Certainly because the reasoning of Lord Justice Elias was premised on, in effect, RB being right in the Court of Appeal. But there is at least a flavour of discharge meaning no longer detained.
As a general proposition, can I put this to you? Discharge must mean release from compulsion, discharge from the compulsory powers, because when we looked at Section 23, that's clearly the sense in which it's being used. And of course, in Section 73, when it's an absolute discharge thing, that's, again, that is the same sense in which it's being used. The problem is, what does it mean in relation to conditional discharge?
Yes.
Because the person is still subject to compulsion, but is described as being discharged. And one thinks it might mean something different in Section 73.
It might. It might. And I was going to say in relation to the arguments under Section 23 that so true it is on the face of 23 that they are doing exactly what my lady's just described. It doesn't necessarily follow that it imports the same meaning when you come to consider it in a different section or in relation to a different concept. I don't take up long on it because, frankly, the argument has been chased up and down the hill a few times, and you've seen the judgment of Mr. Justice Mann, you were taken to it this morning, you've seen the judgment of Mr. Justice Elias, and you've seen Lord Justice Carnwath's judgment in RB, which then went to the Court of Appeal, and frankly all the arguments surrounding discharge as a supportive factor or not on this issue of interpretation have been dealt with there.
I don't want to prolong it, James. It's just that attached to the Court of Appeal's judgment, in this case, we've got Section 17, the Community Treatment Order sections, particularly 17A, and 17, capital A, that is, 17A1, you'll find it after paragraph 67 of the judgment, makes it fairly clear that well, it uses the language of discharge. The responsible clinician who lets the patient out, to use a neutral expression, to a community treatment order, which can have pretty particular terms, is discharging him, which means he's releasing him from the hospital, doesn't it? In that context, at least.
My Lord, in that context, at least. But I entirely accept that. But as I say, there is a debate to be had. I accept to some extent the validity of the points that were being made about Section 23, where it looked like it was dealing with discharge from legal conditions, which didn't necessarily import release from detention. But it depends upon context.
Am I not also right in thinking that a person on a community treatment order is no longer liable to be detained?
There's a specific provision.
There's a specific
somewhere.
There is. I'm having it.
We asked that question earlier, and I think there's a specific provision.
Volume 6, tab 61.
Yeah, there's something to that effect somewhere. But, of course, can be recalled, and recalled by the doctor. You don't need a tribunal or a Secretary of State.
17A2 and 17E. A combination of those two, I think, is what may be of assistance.
Thank you.
Yes, no, it's 17D2B.
17D2B.
Yeah.
So we have these similarities and that difference.
Sir James, before you move on from your eighth point, what is your submission on the eighth point?
Yes. Good question.
So if you're allowed to make a submission that you've no idea what the answer is, but lots of more learned people than me have
It's all
considered
my
it.
fault, I'm sorry.
All wisdom is contained in those three judgments.
No,
If I had a submission, it would be to support Mr. Justice Elias.
But I realise that. Yes. How does it impact?
Well, I think it simply, if you take discharge as importing detention, then it obviously is of some significance to the question whether you can use conditions to impose deprivations of liberty. That's how we put it. And perhaps finally a global point as a result of a point I've already touched on, which is my learned friend's acceptance that under his reading of the power to make conditions, you could impose greater restrictions on liberty. That does create not merely an incoherence in the context that we looked at it earlier on, namely in the context of the rights of review, but it creates a broader incoherence and a broader difficulty of substantially the same kind, which is that if it's right that using these conditions you can impose something which is more restrictive of liberty, it is doubly surprising that you then have a greater restriction on liberty with less or no procedural or criterial safeguards. We, of course, recognise that none of this is easy, and it creates
good.
it creates difficulties in terms of practicalities and impacts, and they flow in particular, I don't want to be insensitive to those, they flow in particular from the cumulative effect of RB and MM Court of Appeal being correct. And my lady's expanded definition, if I'm allowed to call it that, in Cheshire West of what amounts to a deprivation of liberty. And all...
I didn't think we were expanding it. We thought we were
No, well, that may be an argument.
loyally applying the Strasbourg jurisprudence,
Quite so,
as we were directed to do.
Quite so. That may be an argument for another day. but my lady, I'm sure, is right. In a nutshell, all the courts below have expressed some considerable sympathy with the fact that it is likely to be the patient's preference, at least in some cases, to move to less restrictive accommodation, provided, of course, that remains consistent with the interests of protecting others. And true it is that if you expand the concept of deprivation of liberty and you say, well, you can no longer exercise or not exercise the conditions under Section 73(2) on a conditional discharge to effect a deprivation of liberty, you're going to get a greater number of cases. That was my learned friend's opening point. And our answer, however, to that line of argument is firstly that the Court of Appeal in both MM and in B, and their reasoning of the reasoning of those courts of appeal is firmly grounded, I respectfully submit, in principle, fundamentally on the premise that general words don't authorise something as serious as deprivation of liberty for jolly good reason. That principle remains the same, and it's got to be the same in all cases where the existence or scope of that power is an issue. And the reason is because the right to liberty as a categorical thing is of great importance, and people are entitled to know who's entitled to take it away, who's entitled to impose a deprivation of liberty, in what circumstances they are entitled to do that, and when the individual who has that measure imposed upon them is entitled to be released. And if that creates a starker choice across a broader range of circumstances, then that is the reason for it. The second answer to it is the one that I think Lady Justice Arden touches on at a number of points in her judgment, and that is that if there are policy problems that arise as a result of that combination of things, in other words, that being the correct construction under RB of Section 73 plus a broadish concept of deprivation of liberty, then those are policy problems that are for Parliament to consider and develop. It's a difficult and complex problem as to how they should go about doing that, but it is fundamentally for Parliament, and it's acceptable under the principle of subsidiarity that runs through the Convention, for it to be Parliament that sorts those problems. Perhaps the final point to note is the short one, which is that although both of these measures would involve the need for Secretary of State approval, at least of a restricted patient. There are some mitigating factors, as it were, that one can derive from Section 19, which deals with hospital transfers, and Section 17, which deals with leave of absence. Sorry, I said that was the final point. The final point, perhaps, is this, that although, of course, the interests of the patient are going to be considered by any tribunal addressing these sorts of issues, the legislation is pretty strict in terms of what the FTT is required to do and the FTT's jurisdiction and functions under this statutory regime. I'm not going to take time up on it now, but that was the point that was made very recently by the Court of Appeal in a case called Djaba, D-G-A-B-A, Authorities Bundle 4, Tab 38, MS 1550, C in particular, if I can just give you the references, and I'll explain what they decided in a second. Lord Justice Sales's judgment at paras 46 to 54, especially para 50, with which Lady Justice Arden agreed, see para 55, and as I understand it, the Supreme Court has recently refused permission to appeal in Djaba. But in essence, the short point that was being made there was the FTT's functions are pretty carefully circumscribed in the context, I think it was of discharge. They're pretty carefully circumscribed to examining and ruling on whether the statutory criteria, which are for them, are met. And they don't extend more broadly to complaints about conditions in a particular institution, for example. If you want to make a complaint about that, you do it by way of judicial review. Not under the statute, and of course judicial review would go to the High Court. So it's the FTT having a limited role which is restricted to the questions that the statute poses for them. So those are the points on interpretation that we make. Can I turn to consent? And to the Article 5 jurisprudence, if I may. It is clear and accepted that there is, or can be, a subjective element to deprivation of liberty. That point appears clearly from my lady's summary of the principles in Cheshire West. However, one needs to be a little cautious with taking that as too broad or absolute a state of affairs, and there's no particular reason to take it as too broad or absolute, because I think, as my lady pointed out in her judgment, in that case, that subjective element wasn't directly an issue. I think you point that out in that same paragraph. But the appellant here says that where a capacitous person consents, there is really no need to worry about Article 5, and the punchline of all of that is, therefore, no principle of legality, therefore his conception of it works. As I say, I don't accept that, because even if that were right, he'd still have to deal with common law. But in any event, we don't agree that that is the right conception of the Article 5 case law. We do not accept that that case law is consistent in a context such as this, even if there is consent, with the don't worry about Article 5 approach. And that is for these reasons. We respectfully submit that on that Strasbourg case law, compulsory confinement, I suspect it comes back to a point my lady put to me earlier, compulsory confinement is likely to be held to be a deprivation of liberty engaging Article 5, and purported consent will not save it from that characterization. And one can see why, because you drift very quickly into waiver issues and changing of mind issues. They're all bound up in the same thing.
But where do you get that from? The statement in Cheshire West came from Stork, which is just about the leading Strasbourg case.
Until the Grand Chamber produced Buzadji, which I'm going to take you to. Can I take you through that case law?
Yes,
That is not
well,
going to be...
it would help me, certainly.
Yeah, well, I'm grateful. Just so you see where I'm going, and then we'll go to the case law if we may. That's the compulsory confinement element we do place weight upon. And one can see why Strasbourg would do so, because if a person changes their mind and then withdraws consent, they're still subject to the compulsory regime. And moreover, whether a person has a free choice to leave, obviously affected by the imposition of compulsory conditions, goes both to the objective component of confinement and to the subjective element. So it may be quite difficult to isolate the subjective element in the way suggested. And just to make that point, a point which is made by someone other than me, the Court of Appeal in MM, if you just take up the judgment on appeal, para 26 of their judgment, that's the point that they're making in paragraph 26. I should say, whilst we're here, you will see that between paragraphs 23 and 31 of the Court of Appeal's judgment in MM, there's quite an extensive analysis of this set of issues on relating to consent, MS 121 and 122, which we would recommend to the court. But just to go briefly to the case law, if I may, De Wilde, to start off with, bundle 4, tab 39, page 1553, and the relevant paragraphs for present purposes are 64 and 65. That may be a false reference. Sorry, just give me a moment. Yeah. So, can I just invite you to cast an eye down those?
Which 64 and 65?
64 and 65, if you would. Particularly that final subparagraph of 65 on 1583.
Detention could of course violate Article 5, even if consented to, if it didn't fall within any of the grounds in Article 5. There are lots of ways in which things can fall foul of Article 5. And that strikes me as being what that case is about.
Well, that case, there wasn't any... Well, that case is authority... Well, I say that passage is authority for the broader proposition, is it not? Which is that the convention right, the right to liberty, is too important within the meaning of the convention for a person to lose the benefit of the protection for the single reason that he doesn't give himself up, that he gives himself up to be taken into detention. That's the basis for the sentence that then follows, stressing the importance of the right. It isn't, of course, one can breach Article 5 in a whole variety of different ways. My lady is right. You can fall outside the accepted grounds. It can be not proportional.
This one didn't, because the lawful detention of vagrants is one of the specified.
It's permitted.
Yeah.
Yeah.
Well, that's true, but if you go to the head note's interpretation of paragraph 65 is more consistent with what I'm saying than with what you're saying. I'm not saying which is right. The fact that a person has given himself up to the police to be detained did not necessarily mean that he was in a state of vagrancy, or that he was a professional vagrant, or that his beggar, or that his state of vagrancy resulted from any of the circumstances which might, under Belgian law, entail a more severe measure of a detention.
True, but then read C.
Yes?
That's the earlier bit.
That's true, but if you read it in the light of A,
well, my respectful submission is that that's establishing or setting out a broader proposition based upon the reason for agreement.
you wouldn't normally suggest that in relation to the interpretation of a Strasbourg judgment. You'd normally be telling us to keep it strictly within what it was dealing with.
Well,
It's among the many ironies of this case.
I can't have my past sins wheeled out against me.
Nothing to do with sins.
But my submission is that it's recognising the importance of the right that Article 5 confers within a democratic society, which is the right to liberty, and saying that's too big a right to be given away just because someone has agreed to it. Anyway, that's subject to that debate. That's para 65 of De Wilde. And then Osipenko and Ukraine, Authorities 5, tab 51, MS 2012. I know what's going to happen the next case. The next case that I do, you're going to be. So that wasn't what you suggested last time. That paragraph meant. Osipenko and Ukraine, paragraph 46 to 49. Here, the applicant was interrogated in a police station for about 12 hours. There was a dispute about whether he came voluntarily. And the court said a person could be deprived of liberty even if they consented to it.
Yes, that's a direct quote from De Wilde.
It's a direct quote from De Wilde, but it appears to be taking that as the general principle and then applying it as a general principle to 49, is my short submission. That's the... And it's held that the consent doesn't matter if you look at 49, because what mattered was that he would not in fact have been free to leave if he'd tried to do so.
Yes, the point is that he'd gone even supposing he'd gone voluntarily to the police station,
then tried to leave.
The fact that then they detained him didn't make it within Article 5. That's not quite the same point.
Well, it is.
Because what if he'd gone to the police station and said, here I am, do what you like with me. I'll stay as long as you want me to.
Yeah.
Would that have been all right?
Well, my lady, that
may have been a deprivation of liberty.
That may not have been, because at that stage there was no element of compulsion. When the compulsion is imposed, there's a different scenario. If he then tries to leave and they say no and the door is locked, that's different. I do. Of course, I accept that. So at the moment he goes, he may not be. But if he then tries to leave and to exercise his right, then you've got a problem. And to similar effect, II and Bulgaria.
Does that mean that compulsion only arises when he tries to leave and is prevented from doing so?
Well, I think in that situation it probably would do if you went for voluntary questioning. It may be different if you're always subject to the element of compulsion. But compulsion is plainly an important part of it. As my lady says, if you simply go to the police station and say, I'm here voluntarily, then...
Well, if he goes to the police station and he says, I'm here voluntarily, I'm prepared to answer questions, and the police decide as of that moment that if in the future hours he decides he wants to leave, they are going to require him to stay.
If they have power to do that, and that is the regime that operates, then
well,
the element
is there a loss of liberty at the time that the police resolve that if he wishes to leave, they're going to stop him?
I can see that it would be hard to say there was loss of liberty at that point and from that moment, because all that's happened is that the bubble has formed in the mind of the police. I mean, I suspect there's got to be the lethal combination of things that create the Article 5 deprivation of liberty, and they would include the barring of the door or the acting on the bubble that had been created earlier.
He needs to know that...
He needs to know, or the condition needs to be operating in some way, the compulsion needs to be operating in some way.
This case, the kind of case we're talking about,
The compulsion.
the patient knows that in future he will not be permitted to do things.
Right. Quite. Can I come in the last of the cases?
Agrees to it.
Yes, well, agrees to it, which we'll come to in a moment.
Right.
But can I come to Uzaji, which is Authorities Bundle 1. Tab 13, page 600. So here, in a nutshell, the prisoner sought to be placed under house arrest instead of being held in prison. So prison, greater form of detention. He wants the lesser form of detention, which is house arrest, and then later complains about the legality of his house arrest. That's the essential factual context. And the relevant paragraphs are paragraphs 103 to the end of 110. And perhaps the key part of it, if I could invite you just to cast an eye down the totality so you get all of it, as it were, is 106 to 110.
What eventually happened? And that's all about whether he was a victim.
This is about Article 5, is it not? See the title above 103.
Found
Article 5.3.
Yeah,
629.
yeah. And they're concluding, my respectful submission is that in those paragraphs, they're analysing it here as a question of waiver, as it were, but you've got a pretty direct-looking correlation between the more serious form of detention that lurks in the background and the lesser form of detention to which the person agrees. And the question is, what is the impact of that when you come to analyse the Article 5 issues? And the answer to that is you haven't got any form of waiver of rights, or we would add valid consent, because the element of coercion exists. The greater form of deprivation lurks in the background, providing the coercion.
So he had lost his liberty right from the beginning of the house arrest, had he?
He had, I think. That's how the court analysed it, because the only basis on which he'd agreed to do house arrest, as it were.
Because the alternative was even less acceptable.
Exactly.
Was the question actually whether he was being released from detention by being put in the house?
Yeah.
It's the other way around.
He starts in prison, doesn't he, and then goes to
Yes.
house arrest.
And they're talking in 110 about whether it could be equated with release from detention, which is what the government are arguing.
Yes.
So the answer was he was not released from detention because his his detention continued
Yes.
whilst on house arrest, I think.
Yes, that's how it's a little, they put two strands together. That's one of them. And the other one is the direct addressing of waiver, as you see, which is the precise form in which the government had raised that issue at 106.
Yes.
So 109 is the waiver conclusion, my lady is right, 110 is the not release conclusion, but they both essentially flow from the same thing.
The government agreed that house arrest constituted deprivation of liberty for the purposes of Article 5.
It did, and the court accepted that in the light of the reasoning and conclusion in 104. Sorry, I jump around. I select the relevant bits. But so house arrest is objectively considered, as it were, to amount to deprivation of liberty because of degree and intensity and all of that. The question is, what happens? Is he to be treated as released? Is he to be treated as having waived in circumstances where he's agreed to the lesser form of detention? Answer, that isn't release and it isn't waiver.
There was another element. It wasn't just the existence of the worst form of detention, it was also his health was deteriorating.
That's true. That's true.
Case, of course, where it's axiomatic, isn't it, to this case, that the detention was unjustified.
Yes.
Which isn't necessarily going to be true in the cases where conditional release or no is the question.
It may not be, but the question that we're on here is there a deprivation or no?
No, I follow that.
Because that's the thing that informs the approach you take to our legislation. And if I'm allowed to pick and choose from Lord Carnwath's judgment in B...
Well, we will report it, of course.
It's extremely good in part. Extremely good in part, but it's paragraph 62. I don't invite you to turn it up now, but it's essentially this analysis. It's cited in our case at paragraph 44. If you want it in the raw, its authority is 3, tab 31, 1329. So on authority, we say that purported consent, where there is an element of coercion or compulsion, is unlikely to be an answer, may well not be an answer, to a case that you have Article 5 deprivation. And the specific point that one gets out of the Grand Chamber case which we've just looked at is that that outcome is all the more likely in circumstances where the coercion in question is provided by a lurking form of greater detention. It's also to be recognised, to move on to a slightly different aspect, although they all rather merge into each other, a slightly different aspect of Article 5, that it's inherent in the subjective element of Article 5 that a person can change his or her mind. So when the person decides that it was a debate I was having with my Lord Kerr, when they decide they want to leave the police station, they change their mind, they're then prevented, it becomes. And that, we respectfully submit, is the true relevance of Stork and Germany. We might just take that up, bundle 1, tab 11. MS 500 is the first page of it. You'll probably pick it up at paragraph 69. Page 516.
516.
516, my lady, yeah, please. So the applicant
Could you also give me the first page?
Yes, 500.
Thank you.
So bundle 1, tab 11, 500, and we're on 516. And you see from para 69, the basic context. She'd been detained in a mental health clinic. She was detained in a locked ward and wasn't free to leave, shackled if she tried. That was an objective deprivation of liberty, as one sees from para 73. '74, which was the point my lady raised with me earlier on, is, I think, the paragraph you may have had in mind for the subjective element, 517, para 74. And then you see what is now the tolerably consistent mantra in the final sentence of paragraph 75 that we looked at earlier. And then 76 is perhaps the key paragraph. Given that she tried to leave, the court was unable to find a factual basis to infer that, assuming she had capacity to do so, she agreed to her continued stay in the clinic. And on that basis, a breach was found, as you see from paragraph 78. And so that shows that to the extent that the subjective element is there, it's a continuing matter. And is to be judged at the point at which the alleged deprivation is said to have occurred. And so that creates at least potentially a series of different issues in relation to, but related issues in relation to our situation. The subject element of Article 5 envisages an ongoing choice by a person to decide whether to stay in conditions that would, absent consent, amount to a deprivation of liberty.
Where are you reading from, Sir James?
I wasn't, but I was.
Oh, you were. I'm sorry.
I was on 76 as the key paragraph, yes, in this case, and 78 being the conclusion that the court then reaches. And what that leads to is the concern that the Court of Appeal in MM identified at paragraph 25, MS page 121. And that's obviously an intensely practical concern, because if the position is you can just say, well, there we are, I'm no longer consenting to it, and it becomes a deprivation of liberty, they could do that at any time, and then presumably thereafter it would be said the deprivation became unlawful under Article 5. So you've got a problem. You've got a problem particularly if you've got people who, as it were, flip-flop in and out of consent, and you saw the finding of the FT team. I don't know if I fairly took you to that this morning in relation to this individual, but it's a more general issue and problem that the court is there identifying in paragraph 25.
What does the last bit of the last sentence mean? Undermining the protective purpose of the Act's provisions.
Well, it's presumably to ensure both patient and public protection, is it? Because there would then be, the detention would then be unlawful and people would have to react to it. Mm. Not sure quite how. Maybe they'd go back to hospital, in which case they'd be more protected. I see the force of the question. But
okay.
But undoubtedly the first bit of that sentence is right, isn't it? Which is that if they can withdraw consent at any time, the deprivation becomes unlawful when they choose to withdraw it. And of course that does create this whole basket of issues under Article 5 to do with coercion, more serious form of detention, waiver, what the meaning of consent is in this particular set of circumstances, whether or not the patient can change their mind. It does raise a serious question and a serious set of issues in principle about the legislative interpretation that my learned friend raises. I mean, the very concept of the imposition of conditions is such that they will apply whether or not the person continues to consent to them. That's the nature of conditions. It wouldn't make any sense to have consensual conditions, otherwise you're not really imposing conditions at all. And the fact that there isn't or may not be a specific enforcement power is nothing to the point. There's a statutory duty to comply with the conditions under 73(4), and in practice that's enforced by the power to recall in the event of breach. And to go back to the sort of order that Mr. Justice Charles was contemplating when he was considering these matters, it's very difficult to see how you design that sort of order in the real world, an order saying what? So long as the patient consents, he shall be detained in this place or that place. That's meaningless. It's an optional condition. It isn't a condition at all. But if you have an order saying he shall be detained, that purports to bind the patient regardless of consent, and so you've got to justify the detention in the event that it's withdrawn, because the door will be locked. And since it risks becoming incompatible the moment, under Article 5, the moment the person changes their mind, it's not entirely clear what would happen in those circumstances. So I think the way that Mr. Justice Charles conceived, as it were, and I take this from 74(2), subpara 2 of KC, the way he sought to draw the sting from that difficulty was to say, well, it doesn't exclude consensual conditions, and he then draws a parallel with undertakings or with contracts. But of course, the analogy we respectfully submit would be a false one. It would only work if current consent to imposition is irrevocable. And of course, a contract is fundamentally designed to bind people for the future. It's designed to allocate risks and so on for the future, but it's binding in the future. It doesn't have a we can duck out of it whenever we feel like it condition written in. And so there's a fundamental difference between the two, but there's an intensely practical problem there. And it's for that reason that we respectfully submit that both courts of appeal in MM and in B were correct to focus, as they did, on whether or not the sort of conditions that were being contemplated would amount to an objective deprivation of liberty, as they put it. And we respectfully submit that they were correct to do so, because there either is a power to impose those conditions irrespective of consent, or there isn't. And there really isn't any scope for consent to operate in these sort of situations to take you outside the reach of Article 5 so as to avoid the consequences of the principle of legality or equivalent. And of course, where all of that ultimately leads to is a place in which we respectfully submit that it's clear and right as a matter of interpretation that if a power to impose conditions amounting to objective deprivation of liberty could be imposed, and now my learned friend has made his submissions this morning a fortiori in circumstances where they could impose greater restrictions on liberty, one would expect Parliament to specify that power, and they would need to do so in order to conform to the principle of legality, common law, or Article 5. So I move finally to my third topic, which I can take much more briefly, and that is whether or not, if the courts of appeal in MM and RB were right, that would necessarily lead to a violation of convention rights. In other words, if the absence of a power to impose through condition deprivations of liberty, whether that would amount to a breach of convention rights. And the first convention right to consider in that respect is Article 5. And my learned friend seeks to identify as an Article 5 principle a need to detain in the least restrictive conditions. That's the principle he seeks to assert under Article 5, I think by by or through Lord Bingham in H. And I should make a number of points in relation to that. Firstly, you can't assume, it can't be assumed that they would constitute lesser restrictions on liberty. That might be so, but the logic of the argument is that the power exists to make conditions discharging from hospital to a place of greater restriction. And you can't realistically, by a process of interpretation, impose constraint so that the power could only be exercised if it did impose a lesser form or species of deprivation. There's nothing to interpret to achieve that result, and it might be intensely difficult to do that anyway. Secondly, the key focus in Article 5 is, as the Court of Appeal in B pointed out, the key focus is on ensuring that detention is not arbitrary by making clear when and in what circumstances there is power to detain. That, I think, is the point that the Court of Appeal were on in RB at paragraphs 55 and 56. But just as you're going there, can I give you the third proposition that we respectfully submit is correct, which is based squarely on a statement in paragraph 55 of RB, page 340, which is that there is, as they put it, no convention right to a particular type of treatment or care in detention. There is instead, see the second point that I've just made, protection against arbitrary detention by procedural safeguards in a nutshell.
Well, that's true up to a point, but there has to be, the detention has to be in a place which is appropriate to the reason why you're being detained.
That is true.
That's a kind of minimum.
That is a minimum.
Yeah.
And I think the statement of principle that I've just identified from paragraph 55 is consistent with that. I'll come back to develop that in a moment in the context of Ashingdale, which I know my lady will be very familiar with. But the point is that the choice, hence Lady Justice Arden's references to subsidiarity, is for Parliament to make within that acceptable band, as it were. And in any event, we note that overseeing the conditions of detention is not the role that Parliament has given to the FTT. See Dejaba, the case I mentioned earlier. You can JR and go to the High Court to get those conditions reviewed if they're unsatisfactory in convention terms, but the role of the FTT is more limited. I was going to go to Ashingdale, if I may, briefly. I'm going to go to one paragraph of it only, if I can tax your patience to that extent. Authorities 1, tab 9, page 459. Paragraph 44. This is, I think, the point that my lady was putting to me. Can I invite you to read the whole of 44? It's not a very long paragraph, but... There does indeed have to be some relationship between the two, which was the point my lady was putting.
Exactly what I put to you.
Exactly so,
Yes.
almost in terms. But then the punchline from my perspective is in that final sentence. And that is a well-established and well-known principle. Nothing in James departs from it. Indeed, it simply reasserts it. And it was, in any event, reaffirmed as the correct approach by the Grand Chamber in Stanef in 2012. If you go forward in the same bundle to tab 12, you'll find STANF. It starts at page 544 in the MS numbering, and the paragraph we want is paragraph 147 at page 575. Which effectively strips out the bits in the middle of para 44 of Ashingdane and leaves you with the pith. And you see the citation at footnote 92 and 93. And for good measure, it's the principle that is acknowledged and applied in all the cases we cite in our case between 58 and 60. But I'm not going to take up trouble with that. That's the principle. So there is a requirement for there to be some relationship at least. Unsound mind, you ought to be in a hospital. You shouldn't be in somewhere which can't treat you in any shape or form. But beyond that, subject of course to Article 3 limits and matters of that kind, it is for the state to decide how that can be done. Of course, on that basis, the distinction, the binary position that we respectfully submit as the right answer under this Act, hospital or freedom, subject to conditions, is a perfectly acceptable one in convention terms, because the hospital almost by definition is going to be appropriate and suitable. And nothing, we respectfully submit, that was said by Lord Bingham in H, in particular at paragraph 26, which was the paragraph you were taken to this morning, is inconsistent with any of that. As he put it there, I'm not sure it was quite the bit that my learned friend alighted on, but as he put it there, there is a convention object of restricting the curtailment of personal liberty to the maximum. And broadly, of course, we agree with that and don't seek to dissent from it in any way. It means, in a nutshell, that you can't deprive someone of their liberty unless it's absolutely necessary to do so. It doesn't mean and doesn't cut across the principle in Ashingdane, which is that the state isn't concerned with the conditions, subject only to there being some relationship of proportionality between the two. So that, and that is the answer, therefore, to Article 5. Article 8, which my learned friend touched on very briefly, I have to some extent already dealt with, because it is fundamentally premised on the issues relating to consent. And I've got nothing more to say about that. We say that consent is not an appropriate or necessary mechanism for the purpose of these powers. And that's an entirely acceptable scheme under the Convention. You have to have, and it's appropriate to have, a scheme involving compulsory conditions being imposed, both for the protection of the patient and for the protection of the public. There's nothing remotely inconsistent with Article 8 in that. And that leaves Article 14, therefore. And here the appellant says that if we're correct on our interpretation, his Article 14 rights are breached, because a patient without capacity can be discharged into detention using Section 73. And that, of course, as you know, was not an argument that was presented below, and so the court doesn't have the benefit of either upper tribunal or Court of Appeal consideration on the point. It appears to have been based on the Court of Appeal's obiter comment in MM, in other words, in our case, at paragraph 35, MS 123, that it might be possible to use a power to defer discharge, to use the MCA to make arrangements to detain someone elsewhere when they leave hospital. And the appellant seems to be saying, well, assume they're right about that, isn't there? Doesn't that cause problems under Article 14? And I tread into the next bit of territory with some temerity, given that I'm sure it'll be lots of members of the court specialist subject, but it isn't mine. But we have some difficulty with the fundamental premise on which that paragraph proceeds, because of the various provisions of the MCA, and whether or not there might not be a misunderstanding of the application of the MCA to an incapacitous person who's otherwise in the appellant's position. If you go to Authorities Bundle 2, and tab 16, you find the Mental Capacity Act. And if you go to section 16, sorry, I'll give you the page number in one moment, 657, it permits the court, which I think is the Court of Protection, it permits the court to make decisions for a person who lacks capacity, P, as one sees from 16.1, A, and 16.2. But then under 16A, at 16 capital A, on page 659, it provides that the court cannot make an order under the MCA depriving a person of his liberty if that person is ineligible to be deprived of his liberty by this act. That's sub 1. And the welfare order you see defined in 4B as being an order of the kind we looked at within 16.2. The eligibility criteria under this Act one finds in Schedule 1A, paragraph 2, and that's on page 663 of this clip. And we respectfully submit that case A is the appellant's position, someone subject to hospital treatment detained in hospital. And if that's right, he is ineligible.
You want to look for a conditionally discharged patient who falls under a later case? Because obviously we're considering the situation of this person when conditionally discharged. I'm not disagreeing with you in the, as to the eligibility criteria. I haven't looked at it, but
I'll see if there's something. I'll see if there's something else.
I think you'll find there is.
Yeah. In any event, even if there is technically power, my lady may be right, or we'll double check that, but even if there is technically power, we do submit it wouldn't in any event be right to use the power under section 73, including the deferral regime, to permit the discharge of an incapacitous patient on the basis of another regime. It's simply wrong in principle to do that. It would involve, in effect, gaming the regimes. If a person needs conditions to be discharged safely, there should be conditions which are within the power of the tribunal. And you can't, in practice, as a tribunal, impose, or in principle, impose a condition or use a deferral which depends upon or contains or deals with detention under another regime. That's just not permissible, we submit. That's the point that we make in our case at paragraph 68. In any event, and finally, in relation to Article 14, even if there is some difference of treatment, and even if that is acceptable, there are material differences between the positions of the incapacitous patient and the capacitous patient for this purpose, including the absence, in the case of an incapacitous patient, of the problem that we've already gone through in relation to potential changes of mind. So for all of those reasons, we respectfully do not accept that our interpretation of, suggested interpretation of the scope and limit of these powers under section 73 would give rise to a breach of Article 14. Ladies and my lords, those are my submissions, unless I can assist further.
I think we've thrown quite enough at you. We all want to know why the Secretary of State is taking the view that he is.
I don't know if I'm allowed to answer because the Secretary of State has taken the view that that was the intention of Parliament.
You can do that.
I'm not sure I can do. Not sure I can do much better than that.
Well, you can understand why we're asking.
I can, and it's a complex regime which backs onto other complex regimes, and I suspect that there is real concern, and I understand entirely, which is why I addressed the practicalities. I didn't mean to be flippant in that answer, but I mean,
Of course not. Of course you
there are real complications, I suspect, is the worry. If one starts trying to introduce this here, where does it end? Is it actually the right answer here? Or do people, if there truly is a policy problem flowing from the combination of Cheshire West and RB, then that will require some pretty serious thought. The right answer is not, therefore, to, as it were, open this door with all the unforeseeable consequences and knock-on effects that might have. However instinctively and immediately tempting it might be in practical terms.
Thank you. Thank you very much indeed. Mr. Lowe?
No, my lady. I have a series of short points in reply, which I hope will be helpful. Can I start at the end, so to speak, with Article 14? Because and invite the court to pick up Volume 1 of the authorities, tab 7, MS 411, which is the decision of Mr. Justice Charles in KC, where we went through, I say we because I was there, went through the question of eligibility or ineligibility under the less than perfectly drafted or entirely clear Schedule 1A of the Mental Capacity Act. And between paragraphs 94 and 113, there is an analysis as to why, once the patient has been discharged, the patient comes within case B and therefore is not ineligible.
That is what I thought. That's why.
And your ladyship is right. And if your ladyship wants to know why you're right,
no, we can. I'm very happy just to be told I'm right. That's wonderful.
we respectfully submit that's the answer as to why your ladyship is very well honed instincts are completely correct. Next, can I take the court also to Volume 1, tab 10, to the case of Stork, which I somewhat, it starts at MS 473, which I slightly took at a speed below. And my learned friend took the court to part of the judgment. But in order to make my submission on this good, can I invite the court to recall or reflect on or learn for the first time, possibly even, that there were in fact two periods of detention that were in issue in the Stork case. The first was one where it was unclear whether Miss Stork consented or not. And it's quite right that my learned friend took to the observations of the court that in those circumstances you can't give up your right to liberty by accident or by merely not objecting. However...
But she did object because she ran away, didn't she?
But she did object, indeed, and she ran away and was returned. But if you would be kind enough to go to MS 529, we then come to the second period of detention, where a completely different consideration...
You're begging the question by saying detention. What you mean is the second period of hospitalisation.
It's late in the afternoon and your ladyship is completely right. The second period where she voluntarily entered the clinic, if I can use neutral terms. And at paragraph 125, MS 530, the government contested this view. It submitted the applicant as was rightly found by the Bremen Court of Appeal, came to the clinic without being forced to do so. She wished that her medical treatment there be continued, as her state of health had considerably deteriorated. Therefore, she had obviously not been deprived of her liberty. The court states that in respect of the second stay in the clinic, the appellant can only be considered as having deprived her liberty if she had not consented to her stay and treatment in that clinic. And therefore, we have the distinction between the two states of affairs, one active consent, the other a lack of clear consent, and indeed, as your ladyship rightly noted a moment ago, because she ran away and then was hauled back, clear indication objectively. So you can't give up your right to liberty by accident, but you do have the right to be treated in a state of confinement if you choose that confinement. And that's the relevant part from that case. Next, in the same bundle, if we could go to Buzzardi at tab 13, MS 600, there's one aspect of the case which appears in my submission to be important and may have been overlooked by accident, which is at paragraph 107, MS 623. Reference at line 4 there to you do not, in Stork in Germany, the court held that the right to liberty is too important in a democratic society within the meaning of the convention for a person to lose the benefit of protection of the convention for the sole reason he gives himself up to be taken into detention. Detention might violate Article 5, even though the person concerned might have agreed to it. And what clearly, now that we know what the court decided in Stork, the mere fact of presenting oneself, de Wilde, in the first instance, to a regime, doesn't thereafter give license to detain when consent is removed. Hence the important reference to sole reason and to be taken into detention, as compared to the non-coercive, non-duress, active consent, Stork, where there is no Article 5 issue, because at that point the patient is actively consenting. The authorities that my own friend relied upon concerning clarity, legality, and like principles, all start from a position where the individual has unrestrained liberty and the state is intervening in order to take that liberty away. And I invite the court to reflect that this is the other end of the process. This is not the process of taking liberty away. This is the process of progressively giving liberty back to a person under a regime which balances the interests of the patient and the interests of society. And in my submission, that is a crucial difference and is in substance a complete answer, which is where do you start? Here you start from a position where the state is lawfully, and that's the difference with Buzzardi, of course, as my learned friend, as my Lord Hughes rightly identified, because the detention in Buzzardi when he was in prison was unlawful, and therefore if the only way he was going to get out of that was to agree to be under house arrest, that clearly was under duress because he was escaping from a situation of unlawful detention. That's very different from here, where one starts as a hypothesis that the patient starts with lawful detention, properly being held in a hospital for public protection, and this is about the gradual extension of liberty, not the imposition of restrictions. And that fundamental distinction in my submission is the answer to the principle of legality, which is why you should give an expansive interpretation of the condition-making power to facilitate the expansion and the liberty of the person, not a restrictive power to hold it back. This is one of the central paradoxes of this case, that the state relies on the human rights of the patient to stop the patient being granted additional liberty. The fact that there is a theoretical, though there are no practical examples one can imagine, opportunity of greater restrictions, in my submission, should not come in because of the Padfield approach that has to be taken. Can I invite the court to pick up volume 3 at tab 29, MS 1294, the case of SH and the Mental Health Review Tribunal. A decision of Mr. Justice Holman, a judge who has considerable experience in this area, and invite the court to look at paragraphs 17 to 18 at MS 1300. That was also an attempt, and another, we submit, an unsuccessful attempt to use the principle of legality to seek to constrain the effect of the general decision-making power. It was unsuccessful there, and in my submission, for the same reasons it should be unsuccessful here, because if one looks forward in that judgment to page 1304, paragraph 35, the issue in that case was essentially this, that one of the conditions was that the patient should comply with medication. And from Mr. Southey, who represented the patient, effectively said, well, that's unlawful because the patient has an absolute right to refuse medication. And the answer, in my submission, correct answer, paragraphs 35 is, and particularly 36, is that although there is a statutory duty, in fact, the patient retains the right to refuse medication.
That was the point I put to Sir James.
Indeed, and that's the source of that's the authority that I imagine your ladyship had in mind, knowing this area extremely well. That's the authority. Of course, the patient must live with the consequences of his own decision, which we see over the page, MS 1305, 36 and 37. Learned from Miss Levin in her skeleton argument on behalf of the Secretary of State, makes it clear that that may well lead, if it results in a different risk profile, if it results in him not taking medication and therefore being more danger, that may well lead to the Secretary of State being in a position to exercise the right to recall. But that's a consequence. That is the policing mechanism here, not direct enforcement. And therefore, the principle of legality doesn't constrain, what I invite the court to take from this, is the principle of legality does not constrain the width of the powers that can properly be applied, because they must be applied, in my submission, in accordance with paragraph 1718, in a Padfield sense, to promote the principles of the Act. And the principles of the Act are primarily treatment, but also, to the extent that it is required, containment to protect the public to allow that treatment to happen. So you're stopping the patient being a danger to himself and to others and attempting to treat at the same time. And that's, in our submission, the answer to the point of legality. It didn't work in the SH case precisely for that reason, and I invite the court to follow that approach and say it shouldn't work on this occasion, and that the decision-making power of the tribunal is wide. Of course it's wide, but it's wide in the context of the progressive restoration of liberty to a patient, or decisions not to restore the liberty to a patient, or decisions to restore the liberty with conditions, and the requirement for clarity of the basis is there in the power to set conditions, and the requirement to explain the reasons are there in the requirement for the tribunal to produce proper reasons for its decisions. And therefore, the primary features of legality, source of the power, purpose for which it should be used, explanation of how it's used, and explanation of reasons are all present. And therefore, that of itself in our submission is a complete answer. Finally, and I'm in reverse order, section 117 in my submission does not assist my learned friend, because section 117 covers the situation of a patient who has been detained in hospital, and two conditions, and this is MS 232, Volume 1, Tab 1. First of all, who is no longer detained, and secondly, is no longer actually physically in the hospital. But as my Lord Hughes correctly noted, and it was a point we were going to take the court to if my Lord hadn't been there ahead of us, section 17A of the Act, which is not in the bundle at the point with the section 17, but is at MS 130, attached to the Court of Appeal decision in this case, because PJ concerned community treatment orders, makes it clear that a detained patient is a patient who is liable to be detained in a hospital, as well as someone who actually is detained. And essentially, we submit the fundamental flaw running like words through Brighton Rock of Secretary of State submissions, is to equate detention under the Mental Health Act with deprivation of liberty. But in fact, these are two entirely separate concepts, and someone who is detained in hospital under the Mental Health Act, or liable to be detained, is not necessarily deprived of their liberty. Because a patient...
Well, I would certainly agree with you in relation to somebody who's liable to be detained, which is a term of art under the Act.
Yes.
But if they're actually detained...
If they're actually detained, my lady, they are.
They are deprived of that.
But it covers people who are liable to be detained.
Yes.
And if you are on Section 17 leave with no conditions and have been for a number of months reporting on a sporadic basis to your psychiatrist, but otherwise living at home and living a perfectly normal life with no conditions, I respectfully submit that the fact that you remain liable to be detained as a Section 3 patient does not mean at that point your liberty is detained. Nonetheless, within the scheme of the Mental Health Act, in order to be discharged, you have to be discharged under Section 72 or 73. And if the Secretary of State happens to have agreed to your leave under Section 17, you are a restricted patient who is detained under or liable to be detained under the Mental Health Act, given Section 17 leave, but is not actually deprived of their liberty. In contrast, deprivation of liberty can arise through a whole series of different circumstances, as the court well knows, and we're concerned here with the question as to whether the condition-making power under Section 17 necessarily has to be interpreted as containing that limitation when, in my submission, in fact, the concept of detention and under the Act and liability to be detained and the concept of deprivation of liberty are two entirely separate issues. And the question as to why one would interpret provisions in the Act by reference to limitations for deprivation of liberty then becomes completely inexplicable once the difference between the two concepts become so markedly clear. So, on that basis, it is attempting to interpret provisions in the Mental Health Act by reference to the imposition of a condition which we submit has absolutely no relationship, causal relationship or legal relationship to the concepts under the Act. And that was the misunderstanding we submitted to the Court of Appeal in both RB and MM, properly understood in by Lord Justice Carnworth and in the passages I took you to, and is the fundamental problem with attempting to impose the structure of the ECHR onto what is essentially a domestic statute. It simply attempts to shackle the condition-making power with a wholly different concept which has no power and no structure within the Mental Health Act. 2 minutes to 4, unless I can assist further. Those are my submissions.
Well done.
You are definitely all to be congratulated. And we're grateful to everybody, both those on their feet and those who've no doubt contributed to the written arguments that we have also read. And we will now go away and work out what we think the answer is and let you know in the usual way. As quickly as we can, but I don't promise it very quick.